All right, should we go?
Okay, we should go. Yes. Hi. Well, good afternoon, everybody. I'm Neil Kalin. You can probably see in the little corner of your screen wherever you have it set up, Ashley Peterson, our co-host for What's Up With Us, and our special, really special guest star today, our guest interviewee, Judge Marie Wood from the Riverside County Superior Court. And we're going to get right into Marie's interview in just a moment. Let me show you just quickly what we're going to be doing today. There we go. Okay, so, normally Ashley and I banter for a little bit, but we're going to put that on hold because Judge Wood has to get to court this afternoon. So we're going to start with her instead of doing our interview midway through our program. We've got a few cases we're going to talk about. We're going to briefly talk about a law that passed last year that's gotten a lot of attention in the real property world. And then we'll end up with, our announcements. We mentioned this last time, but now we've got a lot of details, and I want to make sure Ashley really mentions those details today. It's really great about the health and wellness retreat. And with that being said, Marie, we don't want to keep your court waiting, so we're going to get right into it. So here we are. We've got our interview, and I think Ashley was talking with you and going over some questions with you. So I'm going to stop, and we're going to turn it right over to Ashley and welcome. I'm sorry, I said Marie. That's not appropriate. Welcome, Judge Wood.
Thank you. Thank you for having me.
We're so excited to have you here today. So for those of you that don't know, Judge Wood was actually on the Real Property Executive Committee until recently when she switched over to the judicial branch. So we're very excited to have you here today, and I'll just jump right in because I know you're limited on time. So why don't you give us a little bit of your background as a lawyer and let us know a little bit about you.
Sure. So I've been in private practice, or I was in private practice for my entire career in civil litigation, mainly dealing with business and real estate issues. I worked for a small boutique firm initially as an associate, and then I ended up, before being appointed, at Reed and Hellyer in Riverside, where I became a partner in February of 2021, and then I was appointed in September of 2021. So my partnership track was very, very short, but it was very nice to get to that point in my career. In terms of practice, I mean, like I said, just a lot of litigation involving businesses and real property issues, quiet title, easements, and all of that, right?
Well, I don't do any of the litigation side, but yes, I am aware. Mm-hmm. You were the one I would call with those questions, we'll put it that way. So how did you first get involved with the real property law section, and then obviously being a member of the executive committee, voting as a voting member?
I love telling this story. My kids went to daycare at the same facility that another member's son went to. And I remember we would see each other just, dropping off kids, picking them up, and hi bye, never really introducing ourselves. And one time we found ourselves at the same park, on a weekend with the kids, and we started talking, and it was a funny, like, I'm a lawyer. Oh, I am too. And so we started having the discussion as to the practice areas that we were involved in, and then just, get distracted by our children. We never touched on the real property practice area. So I think months went by before we had the discussion again. And hey, I'm involved doing all of these things, and I also practice in real property. And so then he suggested, why don't you look into, the joining RPLS, and we have the committee, and this is what we do. And so I that's how I ended up becoming involved. I submitted the application, and I came in not as a voting member, initially, and then after a while, I applied to become a voting member, and that's how I ended up doing that. So
right.
I just love the story just because it was just happenstance, and it took a while for us to get to that topic, and it was just a wonderful organization. I learned so much, and I was so impressed by everyone who's a member of the executive committee, not only because they're just wonderful people, but because of the work that they do. And it's one of the few organizations that I belong to where I really saw the effort that went behind all the CLE that's provided, as well as the different events that are provided for the members. So,
Yeah, that's right. I totally forgot that you were on the committee, but not as a voting member at first. I think you were filling someone's position who
right.
had left. So it was an interim position. And then we brought you on. We converted you to bring you on full time as a voting member. Yeah. And then we were short lived because we lost you to
I know.
judicial branch here. So why don't you tell us about your journey to becoming a judge and sort of what made you decide that that was a route you wanted to go?
Well, I never really thought about it, to be honest. I never thought I want to be a judge, not because I couldn't reach the goal, just because I never thought about it, right? It wasn't until a judge suggested or put that, seed in my brain and said, hey, listen, would you consider this? Would you consider applying? And of course, I was like skeptical. No, it's probably, I mean, who's going to look at me, right? I didn't have, I just didn't have the information that I needed. So I started looking. He planted the seed. I started looking into what it is, what the application process entails, and then finally I decided to submit the application. Started the process. The process was 9 months for me. Very, very intense. Lots of interviews and things to do, but very, very rewarding as well. I was able to speak to so many people, so many attorneys who were so supportive of the process, and I'm very, very grateful to all of them.
That's amazing. Well, I always love to see more women being put on the bench here too, which is always great. So props to you on
I've
that.
got a question about what you were just saying. You said many interviews, and I don't know anything about this process. I've never gone that route. I don't personally know anyone who has, quite honestly. Was it 5 interviews? Was it 25 interviews? You know, how does that process work?
So let me clarify. So everyone who's listening, I haven't scared anyone. There are 2 major interviews, and the one interview is by Jenny, which is they interview just to see your credentials, and then they conduct an investigation to make sure that you are, the legit, right? That everything you put on your application is accurate. Then the other interview is by the governor's office, the judicial appointment secretary. And so there's 2 major interviews. And after that point, the governor decides whether to appoint you or not. The other interviews that I was referring to are really because you really have to have communications with those attorneys in the area who are going to vote, right? When they get that Jenny questionnaire, you really have to get out there and really let those people know, hey, this is what I'm doing. You're not running for election, obviously, but it's communications with others. So perhaps that's the word I should have used. It was a busy time. So don't be scared. It's only 2 interviews.
So what would you say has been the biggest challenge in your transition from private practice to the bench?
Having to stop advocating for one side or the other. It's amazing being on the bench how much clarity you have by hearing both sides, right? But knowing that in my calendar currently, I have typically an attorney on one side and I have self-represented parties on the other side. Or so I have self-represented parties who don't know the process, or sometimes I have attorneys who are new to this area of law and they just don't know how to do something. So my instinct is to tell them what to do, right? Spell it out for them. And that has been the biggest challenge because I can't do that. I'm supposed to be neutral, and I recognize that. I'm definitely still working on that.
Yeah, I can imagine that would be really difficult, especially because you're such a kind-hearted, giving person.
Oh, thank you. Thank you.
So what's been the most
sort of have to
enjoyable?
let them make mistakes then, basically, as you're going through the, okay. All right.
Well, I have to, because I can't really, I mean, the way I approach it is you as a plaintiff, have the burden of proof, you have to meet certain elements. And, but I find sometimes in my head, I find, myself raising an objection. I'm like, oh, how come you're not objecting? I mean, come on, you got to do this, right? Well, I mean, silently, I don't say this out loud, but that's the typical reaction that I have, because I come from with that background, and definitely a challenge that I work on every day.
So then what's been the most enjoyable part about being a judge?
To level the playing field, when I see litigants, and by that, again, having an attorney on one side and having self-represented parties on the other side, you don't always have, the same opportunities, right? So I like to give opportunities to those self-represented parties, as well as attorneys who are new to the area, to be able to speak, to be able to state their case and argue their case. So it's important for me to listen to those parties. Sometimes those litigants this is the first time that they have ever been in court. They want to be listened to. And at the end of the day, whether I rule in their favor or against them, I think they appreciate the fact that I have given them the opportunity to speak and to state their case. So I enjoy doing that, and I hope that that's the effect that this is causing.
Which department are you in? Are you in the civil side? Are you family law, or where are you at?
So I'm in civil. I'm currently in Department S102 in Southwest Justice Center. And I hear limited general civil matters as well as unlawful detainers.
Gotcha.
Mhm.
Okay, great. I bet the unlawful detainers that's just been nonstop since all this COVID stuff has been happening. So I'm sure that's been a very interesting department to oversee.
Very interesting and nonstop learning, like nonstop learning. I see just many unlawful detainer cases that are filed for a period of time where, the law was one thing, and then others that are filed in those other period of time and the law is completely different or currently. So it definitely keeps me alert on those days that I listen to those types of cases. And the number of cases are increasing as the law changes.
Yeah, it's been so nuanced, and just the law is just constantly changed over and over again over such a short period of time. So it's almost impossible to stay on top of what all the rules and requirements are for filing those nowadays. I mean, that's why I don't do them anymore, because the people that's all they do in their practice, they really, have a much better leg up on it than I would, just trying to figure it all out from scratch again.
Yeah, and it's difficult. I tell my staff that I'm a self-described geek, because I just got a new book yesterday and I'm like, oh, I'm so excited about this, right? Because I do a lot of reading. I get a lot of updates, a lot of research, and every day, constantly. I can't say that I memorize everything, because that's just not possible. But I do like to stay on top of the changes. So I'm sure the real property law section is providing those webinars and different presentations to keep everyone up to date as well.
We're doing our best, that's for sure.
Hey, Marie, I've got one more question before we let you, make some concluding remarks. And I don't know, maybe Ashley asked you to say something special. We'll see. But you just said something that made me curious. I'm not a litigator. I don't go to court, so I'm really curious about this. You said you work with your staff. How many staff people do you have?
Well, I have the courtroom assistant, and she does amazing work. My goodness, just amazing work. Who supports me while I take the bench and hear the cases. I also have secretary for other matters. We have the deputy in the courtroom, and then everyone else, all the other clerks and research attorneys who are on staff to support any matters that I have coming up.
Are the research attorneys shared among the various judges, or do you have your own set? I guess I'm not sure how to phrase that.
We have a group of research attorneys, and yes, all judges go to them with a different projects. And typically for me in the limited civil, I don't see many motions that are filed that require someone else to do the research. I typically just do the research on my own, but sometimes I will have competing motions for summary judgment, for instance, where I just need someone to jump in and help. And that's when I rely on one of them to assist.
Thank you. Ashley, why don't you bring us home?
Yeah, so I'll just ask let me ask two quick questions and you can sum them up in maybe the next 3 minutes. But the first one would be, what do you recommend for any attorneys that want to become a judge? What should they be doing to think about now?
Well, I think it's important to be involved, giving back to the community. It's really important for you to do so. But let me just, a word of caution is, you want to do this because you want to do this. It's all about public service. So you need to have that mentality. You also need to have the mentality of, I'm going in not because I want to make money, but because I want to serve the public in one way or another. So what can you do now is get involved in those organizations. I know time is limited, but make the time and do it because you truly feel like you want to do that. And that is important. Keep track, if you're able to, of cases that you worked on that are important to you, where you feel like you made a difference. Not because you won, you got a judgment of millions of dollars, but for instance, you represented someone who you truly believed needed your help, and you were able to do that. And that was significant because you were able to offer your assistance with that. Why? Because the application will ask you, what are those 10 most memorable cases that you have in mind? It's good to have those, set aside and be able to explain them.
That's a great answer. Okay, and then the last one will just be completely non-related to law and just something random, but favorite book or movie or favorite hobby? I
love to read. I love to read John Grisham. I mean, even when I was in law school, I remember always having John Grisham book to read, and other students would ask, how can you read? And we have so much to read, right? But I just love to get into that book and just get myself into another story. For that, to me, it relieves stress. So I don't have a favorite book. My favorite movie of all times is Shawshank Redemption. For some reason, I watched that movie and I was just so intrigued by everything that happened. And then I have young kids, so I have to add that the zoo, the San Diego Zoo, my goodness, I spent so much time and so much money with. Yeah, that sums it up, really.
I love that. That's great. And yeah, I totally am the same way. John Grisham books are great. I love those mystery thriller or like Black Ops CIA type books just because they're so different from the legal dry stuff that we read every day. So it's more of an
Exactly.
escape, right? Yeah. Well, thank
Exactly.
you. Yeah. Well, thank you so much for being here. We know you're on a limited time crunch, but we really appreciate it. And it's so good to see you. And we wish you best of luck with the rest of your career on the bench.
Thank you so much for having me. And thank you, honestly, for all the great work that all of you at RPLS do. It's amazing. Keep doing that and have a wonderful rest of the day.
Thank you. You as well.
Thank you.
Thank you, Judge Wood. Well, so let's, oh, okay, yeah. Judge Wood did have to go to court, so we're very pleased to have her today. And Ashley, so let's see if I can get my screen to move here. There we go. Oh, too far. There we go. So, last month we kind of had just by coincidence, sort of a theme going, sort of like I called it a family feud theme with our cases and our statute. And as I was going through the cases that we wanted to talk about this month, I sort of thought, here was the theme. It reminded me of Forrest Gump, where like life is like a box of chocolates. You just don't know what you're going to get, until you actually take that bite. And some of the cases we're going to talk about, I think the holding was kind of surprising. And also what didn't happen in the cases I thought were kind of surprising. So to me, that was kind of our theme. And you know what, I got to ask you, Ashley. So no, I'm an old timer. I've been married 26 years. What's another Valentine's Day for me? But you are a new, fiance. What was your Valentine's Day like?
It was pretty low key. I actually worked all day yesterday and then we just cooked dinner together and hung out and watched Netflix. It was nothing crazy. I think it's a little overpriced to go to dinners on Valentine's Day because they're always preset menus. And anyway, so it was just more intimate and quiet.
Hey, you're with the person you want to be with. That's the most important thing.
Exactly.
Okay, good. Well, glad to hear it. So let's talk about this case. At least when I first put it up, there was not an official citation yet, but you've got the name, Grief versus Sannon. You've got the date it was decided. You've got the district it was decided in, and it was really kind of an interesting case. I've got two issues here that I'm mentioning, but I think there was like 4 key issues in this case, but we obviously don't have time to go through all of them. So let's just take a quick look at some of the facts of this case. To me, the opening line of the case kind of sets you up for what's going to happen, where the court says, this is a case of seller's remorse, right? So you already got an idea. Okay, so we know how the appellate court is looking at this case. Let's take a look at this. We have a real estate broker, that's Sannon, and he called Grief, who owns vacant land, and the Sannon had a buyer for this 10 acres that Grief owned. Now, Grief is an 87-year-old man, and at least according to his attorney, he had health and cognitive issues. So they met at the property. Agent and the buyer met at the property. This is December 2012. They negotiated a price. Grief was sitting in the car, right? They presented this offer while he's in the car and basically kind of demanded that he sign it right then and there. I said, the property wasn't listed, right? The broker just contacted the seller and said, hey, I got a buyer for your property. Let's see if we can get this done. In the contractual language, it says Sannon represents the buyer only. The seller was unrepresented. Okay. Purchase price of the property, $330,000. The seller, you see, purchased the property for a lot more than that, right? In 2006, like right before the crash, half of it was purchased for $1.8 million. The other half in 2011, before the commercial property market really recovered, for another $480. So what? Almost $2.3 million for this 10 acres. But, in 2012, the commercial property market, vacant land market had not really recovered. So there was a big hit there. So you think, gosh, he purchased for 2.2, 2.3, selling for 330. After signing, Grief reviewed the contract and realized the sales price was $3 million short of what he thought he was going to get, right? So he thought he was getting $3,330,000, but the contract clearly said $330,000. Well, so later on, what happened is there's negotiations about what to do with this. Parties never really come to an agreement. Finally, in November 2014, through counsel, Grief says, we're just rescinding the sale. Buyer sued for specific performance. Seller cross-claimed against the broker for negligence. And then Grief filed a claim for elder abuse. And we talked about elder abuse last month. And for some reason, the case was dismissed. The elder abuse claim was dismissed. And I honestly cannot understand that at all, given the way the facts were presented, even by the appellate court, that you can see says this is just a case of seller's remorse.
Mhm.
At trial, the trial court said there's no common law duty from a buyer's exclusive broker to the seller, and is the way they phrased it, to reveal that the price that the seller agreed to sell for was under fair market value. Case went up on appeal. So let's deal with issue one. Issue one is the negligence issue arising out of the broker to the claim against the broker, right? So what does the court say? Well, negligence requires a duty. Back in 2012, there was no statutory duty from a commercial real estate buyer's broker to a seller, citing Civil Code 2079.16, only applied to residential 1 to 4 property. Later in 2015, that statute was revised to apply to all real property, but at the time of this claim, there was no statutory duty. The court says there is a common law duty of honesty, fairness, and full disclosure to prevent what? To prevent unreasonable and foreseeable risk to the non-principal. So Grief's attorney presented all these cases, in their briefs, but all of those cases were basically cases that dealt with the duty from a seller's broker to a buyer, not a buyer's broker to a seller. So the court said, there's no common law duty here. The seller had access to full information about the property. There was nothing hidden. There was nothing unknown. There was no reason the seller could not find out the fair market value of the property. And the seller could have taken steps to protect himself. He could have gotten appraisals of the property. He could have gotten his own broker. He could have gotten a lawyer. There was many things he could have done before he signed the contract. So the court affirmed the trial court's decision that there was no common law duty. Therefore, there was no claim of negligence against the real estate broker. Do you want to mention anything about that, Ashley? Should I just go on to issue two?
No, I agree. I mean, obviously it was a factor of when the timing was, and obviously that statute wasn't even in play at the time that went into effect in 2015. So, but I tell all my clients that are sellers that they should absolutely get an appraisal of the property so that they don't just accept these low ball offers from some of these, sharks out there that want to get these properties for a steal. So, yeah.
So, but I'll tell you what really surprised me, and Ashley knows, and maybe some of our listeners know, I'm an attorney for the Real Estate Trade Association. So I'm an attorney for real estate brokers. But I have to admit, I was actually a little bit surprised by this ruling. So yeah. If you take the seller's position of what the property is worth, and we're going to see in our next section what the expert witnesses said the property is worth, but what the seller thought the property was worth versus what it was sold for is so tremendous. There's such a gap there.
Yeah.
So I'm wondering, how could you be a real estate broker and not think that something's wrong? How could you not, even though that person's not your client, how could you not think, maybe there's something a little bit off here? Do we really need, and why were they pushing him to sign the contract in his car, right? Yeah. Why couldn't it have waited? till the afternoon or to the next day or whatever it was. So when I saw those things, I started thinking there's something there that just didn't seem right. But
Yeah,
it's hard to argue with the way the court addressed the issues.
Yeah, I agree. I mean, when you hear about these stories in law school too, on some of those cases where people sign on a napkin on the back of their car, I'm selling my property to you for X dollars, and those were upheld, so but I agree with you. I didn't understand why the elder abuse was thrown out, because that does seem to me, given his age and the hastiness of signing this contract and the vast discrepancy in the pricing, why that wouldn't have prevailed. But yeah.
And so we don't know the answer to those questions, and there you go. Now, whether the statute would have made a difference, it's really unknown, because the statute basically says the same thing. It says there's a duty of honesty, good faith, fairness, and full disclosure to be non-principal. Well, that's the same thing that the common law says, quite honestly. So I'm not sure that the statute being applicable would have made a difference, but I guess it would have given the court something else to sort of glom onto in making its decision. So we thought that was an interesting issue. Issue number 2 really has to do with, the value of the property and whether there was unilateral mistake, essentially. And what did the court say? The court said there's no evidence the buyer was aware of the seller's mistake, right? So according to the evidence, what the buyer heard was the seller agreed to $330,000, not $3,330,000. So the buyer was not aware that the seller was making a mistake. The buyer did not do anything to encourage or foster the seller to make a mistake about value. There was evidence from Grief's driver that he actually was mentally and physically capable. And there was evidence that he had signed other contracts for real property in 2012 and 2013. So there's conflicting evidence. Is he competent? Is he not competent? And the appellate court was not going to assert its opinion over competency over what the trial judge said when looking at the evidence both ways. And then dealing with fair market value, both sides put experts as to fair market value. Nobody was even close to the $3,300,000 that Grief was alleging, but there was a range somewhere between around $500,000 and around $700,000. And so and the court spent a lot of time on the $700,000 appraisal, $700,000 value, saying, well, the $330,000 is not that far off because there was no entitlements and stuff like that. And I'm thinking, that's less than half the value. It's one thing to say, hey, I'm getting a good deal from my buyer, I don't need to tip off the seller, but half the value? I don't know.
I don't think the lack of entitlements would allow for that big of a discrepancy in the price. I mean, I could see maybe $100,000 off for no entitlements, but no, not $400,000. No.
So anyways, it's really a good read. It's a long case, a lot of good stuff in that case. So that's good. So let's go on to our next. And here we have the San Francisco Apartment Association versus the City and County of San Francisco. And again, real recent case decided just on the 24th of last month out of the First Appellate District. I put in the daily appellate report site for those of you who get your information that way. And Ashley, do you want to lead the discussion here?
Sure. Yeah. So I love that we're like cutting edge on these cases. They're not even officially published yet. So it's great that these are all hot topics, Neil. So good choices. Okay. So this one, basically is between the San Francisco Apartment Association and the City of San Francisco over a statute involving residential properties. So under the Costa-Hawkins Act, which is Civil Code 1954-52, homes that are constructed after February 1st of 1995, as well as single family homes and condos, are typically exempt from those rent control laws. And so basically owners can set their own rental rates for properties that have become vacant that fall under those exemptions. And that statute actually specifically preserves the right for local authorities to regulate grounds for eviction. So in this case, that would have been the city of San Francisco. So in January of 2019, San Francisco adopted this ordinance that made it unlawful for a landlord to recover possession of a rental unit that was exempt from the rent increase by imposing a rent increase in bad faith, basically by inducing the tenant to leave because the rent increase is so high that they can't afford to stay there anymore. So the court kind of discussed all the different factors of what goes into bad faith. And that included, that the rent was so far in excess of market rates at that time. The increase was within 6 months of an attempt to recover possession of the unit. And basically anything else that the rent board deems relevant. So with all those factors in place, they're basically saying can't raise the rents too high and then try to kick somebody out for purposes of doing that. And obviously a violation of the ordinance was tenant harassment and a defense in an unlawful detainer case. So the plaintiffs, the apartment association, filed a petition for writ of mandate seeking a declaration that the amendments were unlawful and preempted by state law. So they're saying because we're exempt under Costa-Hawkins that we should not have to fall under this San Francisco specific ordinance. So the trial court said that the San Francisco ordinance was not preempted by Costa-Hawkins Act because it doesn't regulate rent. So a lot of the arguments made by the plaintiffs was that the San Francisco ordinance somehow prohibits, owners from being able to set their own rent rates when they're exempt, and that's a violation of their rights as landlords. But the trial court did not agree to that. They appealed. And the appellate decision affirmed the trial court and said that it didn't allow pretextual rent increases that a landlord did not intend to collect to be used to avoid eviction control measures. So basically they were saying that the point of this statute was to prevent landlords from acting in bad faith and imposing extreme rent increases on these tenants to try to get them out so they can charge a higher rent for the new tenants coming in. And they just wanted to protect the point of the statute was to protect the tenants from that bad faith action, and that it would be easy to determine a situation of bad faith as opposed to not. So appellate court affirmed the trial court.
So when I was reading this case and when I was looking at the decision, a couple of things stood out in my mind. One, the challenge was to the ordinance as it was, not as it was applied to any particular circumstance. And so the ordinance was upheld, but there's still a possibility that if somebody raises the rent and they think they're raising the rent to market value, the tenant complains that it's a violation of the San Francisco ordinance. And if the rent board and if the reviewing court says, that is a violation, at least there's the possibility on a factual basis that one can challenge a specific rent increase. And I know, particularly in San Francisco, you have a lot of landlords who believe, rightly or wrongly, that the rent board in San Francisco is just so skewed towards tenants that they may have a very different opinion of what is fair market value versus what is excessive, rent that is being charged. And so we'll have to see, going forward, if there will be any challenges based on determinations that the rent board or reviewing court, winds up making in the particular situation. And so, yeah, I'm sorry, go ahead, Ashley.
No, I was agreeing with you. Yeah. I mean, if you look at the historic rent increase allowed limits for rent controlled properties in San Francisco, I mean, the amounts are so super low. I mean, it's been like 1 to 2% for the increases annually that are permitted for the properties that are, under that rent control. So obviously people who are exempt want to be able to charge whatever they can, to new tenants coming in or to existing tenants who've been there for a long period of time. So a lot of times they'll increase, I think the situation though that they're trying to address is there was a case that they cited in there that was, a landlord who increased the rent by 100%. So, I mean, yeah, that would clearly be excessive under the circumstances. And they were saying how that was a clear situation of bad faith. So,
And in a situation like that, you got to remember that landlord, since it was exempt property, was probably already starting at fair market value rent in the first place, and then doubling the rent. Well, I know rents, have gone up, but have they doubled? I guess it all depends on how long the tenant's been there, whether there was a freeze during that time or whatever. But yes, that's going to be the next big issue, I think, to come out of the San Francisco ordinance, which is how it is being applied on particular factual circumstances. Okay. All right, anything else?
yep.
No. Okay, so let's go on to our third and last case. And for this one, we actually have a citation. It's a little bit older. It was decided at the beginning of January of this year. So we actually have an official site for it. And the Johnson versus Little Rock Ranch. And this is another case, and you could see if you just scan, you don't even read this whole screen, you see down at the bottom, there's a dissent. And I love cases with dissents, because that means this is a really tough case, right? And not everybody's going to look at it the same way. And that sort of goes to my theme, which is, hey, surprise, you don't know how some of these things are going to turn out. So let's go through some of the facts of Johnson versus Little Rock. So Little Rock acquired multi-acre, 677 acres in the middle, I think, of 2012. Wanted to develop a walnut orchard on this property. To the south of the property, there was 210 acres owned by Johnson. So Little Rock to the north, Johnson to the south. There was a fence between the two properties, and the fence actually was 5 feet onto Johnson's property. Right? So there's a 5-foot strip of land that may look like it belongs to Little Rock, but actually belongs to Johnson. You take that 5 feet along the full length of the property, and it comes to more than 3.5 acres of property, added up. Previously, both of these parcels, the now Little Rock and the now Johnson property, were owned by members of an extended family. They were kind of aware of what was going on. They sort of knew what was going on. And at some point, Johnson told Little Rock's predecessor, the seller of the property, in 2010, hey, the fence is not in the property line. Now, Johnson didn't do anything about it. Johnson didn't move the fence. There was never an agreement written agreement regarding usage or easement or anything. But the seller was told affirmatively that the fence was not on the property line. The seller did not tell Little Rock during the sale. Okay? The real estate broker for that sale between the seller and Little Rock was a dual agent, and actually told Little Rock that the fence marked the property line. Now, this case does not involve the real estate broker. So that was kind of a surprise to me. It's like, the broker said the fence is on the property line, but it's not. For someone who advises brokers all the time, you never make that statement. You always attribute, and then you disclaim. So you would say something like, the seller told me the fence was on the property line, but I have not verified. You need to get your own inspection or title report or something like that. Right? But amazing to me that this case did not involve the real estate broker.
Me too.
Yeah.
Especially
So,
dual agency situations, which always end up in bad situations.
Of course, but I didn't notice anything in the case. So, maybe there was a quick settlement. We just don't know. Well, not only was there that representation, but the preliminary report indicated that the fence encroaches on the neighbor's property in multiple areas, but did not say how far and to what extent. The sale closed early 2012. After that, Little Rock grades the land, buys trees, moves dirt, excavates the slope. So the fence was sort of at the top of the slope going down, right? Excavated the slope to make a more plannable area, planned and designed an irrigation system, all sorts of stuff, okay? A little bit later on, we see in the dissent what happened is that the Johnson sent a letter to Little Rock saying, hey, wait a minute, you're on my property, okay? Finally, in March of 2013, so like a year after the purchase, right? Provides Little Rock with a survey showing the exact differential. Little Rock offered to buy the strip. I don't know for how much. I don't know why it was not accepted, but there was no agreement to buy the strip. Finally, Johnson said, well, I gotta file a lawsuit for trespass, conversion, and injunctive relief saying, hey, give me all my property back on that 5 feet, that over 3.5 acres. The trial court said, hey, Little Rock, you're trespassing. No doubt about it. You're on somebody else's land. There was no agreement that you had the right to use it, but we're going to deny injunctive relief really for 2 reasons. 1, for laches, and 2, we're going to apply the relative hardship doctrine. And the trial court said, Little Rock, you're going to have to pay damages to Johnson. You're going to have to take corrective action to make sure that there's no erosion of Johnson's property because that hillside is gone. Okay, and Johnson, you're going to have to deed that strip over to Little Rock. The appellate court affirmed, and the appellate court said, well, let's look at the laches claim. And the laches claim what that's an equitable remedy. Courts have equitable powers. Laches applies if there's an unreasonable delay which prejudices the defendant. Court says laches will be sustained as long as there's substantial evidence to support the ruling. Here they said Johnson, in 2010, told the predecessor the fence is over the property line, but made no attempt to move it. The fence actually was there for, there's at least 5 decades. Never notified Little Rock of the dispute until November of 2012, after the grading was complete. Right, and that was what, 7-8 months after Little Rock purchased the property. On the relative hardship claim, the appellate court said, well, here we balance the equities. They set out the test to be used, and then they said, well, we're not going to interfere with the trial court's ruling unless it falls outside the bounds of reason. Did the court exercise reasonable discretion? Even if we disagree, that's not enough to overturn the ruling. And here there is grounds. The dissent I thought was very interesting. The dissent mentioned that Little Rock had this prelim. They received it and they approved it. The prelim that disclosed the fence was not on the boundary line. So they knew that there was a problem with the fence, or they should have known if they bothered to read the prelim. Okay, so the Little Rock says, well, there's always problems with vacant land. Fences are never exactly right. But the dissent says, well, that's why you should have investigated. You were told it wasn't on the property line, and you were aware from your own experiences that there are problems. So the court said, you were not an innocent trespasser. You knew that there was a problem with what you were doing. Because you were not an innocent trespasser, you don't qualify the balance of the equities for the relative hardship. And the court said for the laches argument, true, this fence may have been there for 50 years, but there was never any issue that put Johnson at risk of losing the property until Little Rock came. But Johnson was an absentee owner. So they were not there to see Little Rock excavating the property and planting trees and all that stuff. They weren't there. So the fact that they gave them notice in November, that's only 6 months after the purchase. And what happened? Well, even after they got the notice, Little Rock continued to do work on the property. The court said, you know what, the equities don't work here. The dissent said the equities don't work here. The dissent would have decided for Johnson on their particular claim. How do you look at this, Ashley?
I don't know. It's so, like you said, if they're not there and they couldn't see what was going on, I don't know how they would, be able to have been put on notice about that. I guess, obviously, everyone should read their preliminary title reports. I mean, that's the takeaway from this, right? I mean, I do that with my clients on a daily basis. So, yeah. But it sounded to me like the encroachment wasn't something that was recorded. I mean, it's not a recorded easement document or anything. So other than doing a survey, I'm not sure how that would show up on the preliminary title report necessarily. So that was an interesting question I thought of when I was reading it. But
Well, when I saw this case, my takeaway was I really wondered what kind of offer Little Rock made to purchase the strip from Johnson. Obviously, you know, in hindsight, boy, Johnson, that may have been a mistake. I don't know. I don't know how that compared to what the court ordered Little Rock pay you, but you could have avoided years of litigation, right? You could have avoided, like 7 years of litigation.
I'm sure the cost of that strip of land would have been far less than what they paid to litigate and appeal this case.
And so to me, like, you know, kind of one of the lessons is not a real estate lesson, but kind of a pragmatic lesson, which is, you know, negotiate. If you can't negotiate, hire a mediator, right? Because sometimes a mediator can get the parties to see their weaknesses, the value, the strengths, the poor parts of their case. And maybe, as I say, from 2012 to 2022, you know, maybe this could have been resolved, you know, a long, long time ago.
Yeah.
You know what? Hey, Ashley, I have this statute I was going to talk about, but we're kind of running low on time. So I'm going to skip over that. Maybe we'll handle that at our next session, okay, in March.
Okay.
So we're going to go past, if I can get this to work. Yeah. Well, okay, so I just passed SB 9. So for those of you who don't know what SB 9 is, that's the statute that some people say eliminates single family residential zoning in California. That's not exactly the case, but we'll go over that next month. But I want to talk about a little bit since we're getting near the end of our time here. So what's going on with the real property law section? I listed some of the webinars that are coming up over the next few weeks. You see a lot of reruns there for our webinars. So not a lot of new webinars, but what our webinar chairperson does, Nancy Goldstein, who's one of them, that we actually have 2 chairs, is she picks out, she goes, what webinars received the highest number, you know, of views that attracted the most interest from our members. And so every once in a while, we'll pick some of those and replay them because we know members are interested. So I wanted to point a few of those out to you. And you see on March 16th, most webinars, by the way, are from noon till 1. The one on March 16th, there's a whole series about global leasing and leasing in different countries. And great presenter, right? That's Joanne Woodson who does that.
Yeah. I think she's doing one a month, and it's for like 12 months. They're pretty amazing. They're all different countries, and she actually gets a leasing attorney from that country to be interviewed by a moderator who can, you know, ask them questions about how our practice in California differs from the practice in Spain, for example, or Japan or the Bahamas. It's really amazing and such a cool idea. So if you have time, definitely sign up for those seminars. There will definitely be a bunch more coming over the summer and the next few months. So keep an eye out for those if any country is of specific interest to you. I think I'm in May and I'm moderating one for, oh shoot, I can't remember which country it is. I think it's Germany. Sorry, it's so far out that I have forgotten, but yes, keep an eye out.
As long as you know by May, Ashley, that's okay. Okay.
Yeah, I will.
You see, those are all in the evening, so it's kind of nice. You don't have to give up time during the day. So, you know, but if anybody listening to us, if you've got a good idea for a 1-hour webinar that you think would be interested to real estate law practitioners, let us know. Send Nancy an email with your idea, and you can have a bunch of people listening to you as well. And let's talk about, you know, I'm going to skip the wellness retreat just for a minute. Just so, by the way, if anybody has ideas for short articles you want to get published in our monthly newsletter, there you go. You can contact Kyle Yagi, right? And if you have an idea for a long article, a law review type article, lots of citations, right? All that stuff that you probably maybe haven't thought about since law school. Well, then contact Norm Chernin and you can get published in our very prominent real property journal. But now I'm going to go back to that middle section that I skipped. You know, you mentioned it last month, Ashley, but now there's like a site, a sign up site, there's information. So I'm going to turn over the Real Property Health and Wellness Tree to you.
Yeah, so this is super exciting. I hope everyone who's listening will sign up for this. It's April 22nd to the 24th in Lake Tahoe, and it's at the Ritz-Carlton, which is a super swanky, awesome venue. And it will be a combination of real property and wellness topics. So basically, the entire event will kick off Friday night with a welcome happy hour, and we'll have a movie night and s'mores. And then Saturday is basically going to be a half day of seminars and then a half day of activities. So we'll start with some morning yoga. There will be a core workout class, and then we'll have a breakfast keynote speaker on attorney burnout. And then we'll have some concurrent panels on both real property law topics and wellness topics. So I think the two real property topics are the top 10 cases of 2021 in real property. And the other one is on landlord-tenant law changes. And then the other panels are on managing substance abuse issues for attorneys, and how to manage stress, time management and stress issues and positivity things in practice. And then we'll have a lunch with a fitness coach speaker who will talk about how to attain those goals and get rid of bad habits and things like that. And then we'll have a guided hike in the afternoon and some beer tasting and dinner on the Lake Tahoe ferry. So it's going to be a super fun-filled, exciting weekend, and it's family friendly. And we have early bird pricing available right now. So definitely sign up before the end of this month to take advantage of that, because it's like $100 off of what you would normally pay. And there's family pricing as well for tickets, and you can get up to 5 hours of MCLE credits. So I put the link in the chat there. It's also on the slide, but there's the schedule and information about the hotel pricing. We have a discounted rate at the Ritz and discounted rates for the retreat. So get on it. Don't wait till after February 28th, because then you'll have to pay more.
So this sounded so good, Ashley. I got myself in some financial trouble. I have 2 adult children. So I said, hey, you know, there's this retreat. I'm going to go there for the real property section. You know, there's some fun activities. You know, would you like to go? I said, you know, on good old dear old dad, right? And so my son, who works in the high-tech industry and basically makes more than me, said, a free stay at the Ritz? Of course I'm going, right? Okay, well, I can't invite you and then not invite my daughter, right? So it's like, okay. Anyway, we'll see. And they're probably a little bit too old for some of the things I said. I've got adult children. I'm curious, what is ladder golf? Did I write that down right?
Yeah, it's I don't know if you've seen it, but it's like a thing with like 3 prongs. It's like a wall. It looks like a ladder, sort of, but it's 3 levels. And you throw a thing that looks like it's got 2 balls on the end and a rope in the middle. You throw the ball and it tries to wrap around the little ladder. So it's really fun. It's a fun game. Cornhole, ladder ball. You know, there's all ages are welcome for this event. There's not anything that's like specific for young kids or old kids or anything. But you know, the hike will be all levels. The yoga will be all levels. So we just hope everybody can come and partake, and it'll be a super great weekend.
It sounds like just a great way to get together with some other people, some other real property practitioners, to meet others who have similar interests to you. Not to spend the entire day going to seminars. Like you said, Saturday, you're going to be done by noon. What about Sunday? Is there anything Sunday morning, or is there going to be a hike or a yoga or something in the morning on Sunday?
Nothing planned on Sunday. That's sort of a free day for everybody. I mean, most people will probably be traveling back that day. Yeah. But I'm staying the whole day on Sunday and probably go for another hike or do something on the lake, or I don't know, rent bikes maybe. So there's plenty of options, things to do. And I'm just taking advantage of a couple of days up in Tahoe. So.
Well, it sounds like a fabulous weekend, and the fact that you're working on it, Beth, whose screen is blacked out there, has been working on it, and And I know you have some others who are sharing the event with you, are working as well. So please sign up, really take advantage of the early bird pricing. Since I put myself out there and I'm paying for, others now, I'm definitely gonna take advantage of the early bird pricing. I hope you join us next month, March 16th. We've got another speaker. We'll talk about the SB9, and there's already a couple of cases that I know I want to talk about. So we'll see what else new comes up. Maybe something brand new that we won't even have a site for. Okay, 2 o'clock. I gotta go. Ashley, anything you want to say as we head out?
Nope. Thanks so much, Neil. Appreciate you.
All right. Thank you. Bye, everybody. See you next month.